from the Uda. All my niggas turn shooters. All my ops turn rats. All my niggas turn shooters. On the internet, you ain't been a threat. You been stuck in a computer. Show me the proof. All my niggas turn shooters. All my niggas from the Uda. All my niggas from the Uda. All my niggas turn shooters. All my ops turn rats. All my niggas turn shooters. On the internet, you ain't been a threat. You been stuck in a computer. Show me.
You already know the vibes. You already know the vibes. We back with another one when it ain't no other one. Listen, we got Timothy Rush. His case exposed. We gonna get into his case. I think we gonna do that tonight, right? We already did one piece. Now we about to get into it. So we got CUFFY Gatling, MEECH, Big MEECH, that is, TAMMY Cowens, the heroin use, the DEA reverse sting, the lies, all kind of thing, the sham narcotics they were supposed to have gotten. He was supposed to have been the driver, supposedly. Yeah, we're going to get into all that. Salute to everybody in the building. You already know the vibes. Salute to y'all, man. Salute to y'all. You know how we getting it, man. You know how we getting it, man. Nothing is done without the Most High. And on this channel, nothing's done without y'all. So remember, salute to yourself. Salute to this. What we doing, this is the Go Gang. Be a part of the Go Gang. Subscribe to the channel. Lean on that like button. It costs you nothing to push that button, all right? Just understand that. It costs you nothing to push that button. We are going to be going into a read, okay? This read, we're not going to get into this read. You know what I mean? This is something else. We're not going to get into that. You feel me? What we're going to get into is this. We're going to get into that, all right? And that right there is Timothy Lamont Rush's case, all right? This is what we're getting into. These lights just be so bright. After a while, I look in these lights a lot. Salute to y'all though, man. Like I said, make sure y'all all dropping likes on your way in. I appreciate the love. I'm going to be going into a read, so I'm not going to be able to be telling y'all drop likes. And when I'm reading, I just like when y'all dropping likes. You feel me? Because I'm reading. And I'm reading this because I want everyone that's watching this, everyone that's viewers, to be able to understand what the hell's going on in any of these paperworks. We want to understand it all together in real time. Some people are online and they're talking from different viewpoints, but a lot of times, I met one the other day, a guy, and he really didn't read the paperwork. So I suggest everybody to read the paperwork, especially the ones that's free. You should go about reading it, all right? Salute to y'all for that. All right, cool. So we're going to go into a breakdown, and we're going to start exactly where, a little bit right before where we ended off on our last video. So salute to that. Salute to y'all. We just waiting for 3 minutes, and we're going to begin because, you know, that's what they say to do when you really do YouTube videos. So salute to y'all. All right, cool. So now we're going to get into this breakdown. Make sure y'all hear me right. Yeah, y'all hear me right. Let me just check my sound anyway. So now we're going to get into yeah, y'all hear me clear. Good. All right. Rush contends evidence revealed through disclosures from the United States and presented at the Franks hearing goes to the weight of the United States. Case against him, though, which is one of the factors the court must consider in evaluating whether to detain under the Bail Reform Act. While I certainly consider the strength of the government's case, including evidence that there were Title III wire intercepts, in assessing whether or not to grant the United States motion for pretrial detentions. The strength of the government's case was not material to the order of detention, rather as reflected in the detention order and set out above. Rush, hold on, let me scroll. Cool. It says Rush's personal history and characteristics such as lack of employment, extensive and serious criminal history, repeatedly poor performance while under court supervision, ongoing chronic and long-term history of substance abuse, and evidence that he was under supervision at the time of the instant arrest, together with the rebuttal presumption for detention, drove the decision to detain him pending trial. I also considered Rush's criminal history, which reflected that he was on parole at the time of the instant charges and had a poor history of compliance while on supervision, including a history of absconding from supervision. You know what I mean? When you going on parole and probations and all these things, and you bouncing from these things, and he's just doing these little things. All right, cool. Warrants and all type of stuff like that. All right, cool. In addition, the United States pointed out in its response, it appears that even if Rush were to prevail on the Franks motion, it is not at all clear that the strength of the United States case against Rush would be greatly diminished. Rush is implicated primarily as the driver in connection with the purchase of sham narcotics in DEA reverse sting operations that took place in February 2013. Rush has failed to explain, if at all, suppression of wire intercepted evidence obtained from Gatling's phone would take away from evidence derived from the reverse sting operations at the heart of the United States case against him. In sum, even if the factual issues in the Franks motions are decided in Rush's favor, that result standing alone would not be a basis for reconsidering pretrial detentions under the Bail Reform Act. Other than the evidence presented at the Franks hearing, defense counsel offered little in the way of new evidence that was not previously considered by the court for the reasons already stated. The evidence related to the Franks hearing is not material to the analysis under the Bail Reform Act. Evidence proffered at the hearing was both new and material to the pretrial detention inquiry, including evidence that 1. Rush is currently sober due to his years of pretrial incarceration. 2. After years of pretrial discovery, there is nothing to suggest that Rush's role in the reverse sting operations was any more significant than that of a driver. 3. There is no evidence that Rush had any weapons or money on his persons at the time of the sting operations. And 4, there is no evidence that Rush has either on his own or at the direction of Gatling or anyone else perpetrated any acts of violence against a witness, victim, or suspected informant in connection with this case. And 5, there is no evidence that Rush had any involvement in the murder of his alleged co-conspirator, Morgan. The foregoing evidence, which was unknown at the time of the initial detention hearing, tends to favor Rush and to some extent makes the question of whether there is clear and convincing evidence that no conditions would reasonably assure the safety of the community a closer one. However, other than evidence of Rush's current state of sobriety, none of this new evidence addresses the primary concerns reflected in the initial detention order. As such, the new evidence presented by Rush is not sufficient to overcome the key factors on which the initial order of detention were predicated. Make sure y'all dropping likes over there. Okay, make sure y'all dropping likes. We reading, we building. I'm reading this for us so that we can all get an understanding of this. I'm also reading Terry White's case a little bit later. I'm also reading some of Cuffy as well. So we're ping-ponging a lot. Because remember, he's Cuffy's co-defendant. All right. This is Cuffy's co-defendant. So this is one of his co-defendants at least. So we are just going through a quick little breakdown and just trying to figure out what the hell's going on with this. You feel me? So make sure y'all all dropping likes. It doesn't matter if it's just a couple of us in here. We just drop our little likes and we just getting that information out. And that's all we doing. So salute to all of y'all. I appreciate y'all. Let me get back to the thing, right? Extensive criminal history. Rush's equally extensive history of poor performance while under supervision and Rush's apparent propensity for committing new crimes while still completing a sentence for another offense. In sum, for all the foregoing reasons, the new evidence presented by Rush is either not material to the inquiry under the Bail Reform Act or due to other evidence in the record as a whole, the new evidence is not a sufficient basis under the Bail Reform Act for ordering that Rush be released pending trial. Now they're going to a pre-trial release on a due process grounds. So let's see what they're talking about here. Defendant Rush argues in the alternative that he should be released because his pretrial detention, which currently stands at 44 months, damn, he was locked up for a couple of years, right? For 44 months, has become unconstitutionally excessive. The Due Process Clause of the Fifth Amendment provides that no person shall be deprived of life, liberty, and property, and or property without due process of law. An individual may be detained prior to trial without violating that clause, so long as that confinement does not amount to punishment of the detainee. This is because although liberty is the norm, the government's regulatory interest in the community safety can, in appropriate circumstances, outweigh an individual's liberty interests. Neither the Supreme Court or this is breakdown, man. Let's go to the guts, man. This ain't guts. This fluff. Oh, man. Instead of the issue of whether the pretrial detention case by, hold up, let me see. Non-speculative, to the extent the government bears responsibility for delay. Okay, that's just for more emotions and things that he's trying to suppress. Although no one is affected of a review in the case confronts in the due processes challenge suggests 2 years or more. Okay. They just still talking about that. Okay, hold up, wait. Where defendant was detained for, wait a minute, let me see. Hold up. Let me see if they're talking about a random person. The stronger the evidence justifying detention must be, it is deemed sufficient to justify the detentions where defendant detaining for more protect. Okay, I thought that they had him for some of them trafficking charges or something. All right, cool. That's not him. Hold up. Okay, let's read right here. Let me see. Let's start from right here. Let's see. Okay, let me see. Where the affidavit. Okay, if not the rare case where the length of a pretrial detention alone amounts to a due process violation, the case came close, and at minimum, the extended length of pretrial incarceration called for heightened scrutiny. Canvassing the law and holding where non-speculative length of detention would be at least 35 months. The other two factors of due process analysis, government responsibility for delay and threats to the government's regulatory interests, needed to weigh strongly in favor of the government to justify the continued detention. Canvassing the cases from the Second Circuit Court and holding that 50-month detention of defendant charged with gang-based racketeering related to drug trafficking activity and possession of a firearm in furtherance of drug crimes presented rare case where length of pretrial detention alone offended due process, where the case was still many months away from being ready for trial. Okay, so let's see. Okay. There's no dispute, Dorian. There's no dispute. The duration of detention in this case falls squarely in the very long category. As for the writing of this order, Rush has been in custody for 44 months. By the United States estimation, March 2018 is the earliest case will likely be ready to go to trial. As such, the earliest defendant can expect to go to trial is 4 years, 48 months after he is ordered detained pending trial. However, as defense counsel accurately pointed out during the hearing, a March 2018 trial date seems overly optimistic given the status of pretrial matters. Although the Franks issue is now submitted and ready for ruling. The defendants reserve their right to file other pretrial motions related to physical evidence, statements, and other non-electrical surveillance evidence. Those deadlines have yet to be set, and any pretrial motions related to non-electronic evidence have yet to be filed and resolved. In sum, The non-speculative length of expected confinement in this case is no less than, and in all likelihood will exceed 48 months. Given the length of the detention in this case is approaching the duration that some courts have found standing alone offender due process, this factor weighs very heavily in favor of Rush. Okay, let me see the extent to which the government bears responsibility for the delay. Let's see why they doing the delay. Let me see. Detention, significant portions. Hold up. And why they want to delay it? Hold up. You know they always got a reason to want to delay some shit. Yo. Hold up. Let me see. Okay. Okay. Speedy Trial Act, man, for real. Let me see. Okay, more specifically during the course of this already complex case, prosecuted the okay, cool. Let me just read from my head. Let me see. In the Speedy Trial Act, over time, however, the case became more complex due to a combination of circumstances, some of which were beyond the control of any parties. Hold up. Let me see what's going on in this chat. Salute to everybody in the building. We in the building. We rocking now. We just reading this thing. We trying to get this thing right. Let me check and see how we looking. Everybody that's rocking with us, I just want y'all to drop a like. That just get this message out. We reading, we building. I just want us all the paperworks. I just want to read them and I want to share them with y'all. If y'all need me to share them, that's what I'll share. Because I want us all to have the information and not just listen to YouTubers, me and whoever else, and think that everybody knows it. No. The paperwork tells a story, bro. That's what we have to stick to. So salute to everybody that's rocking with us. Y'all know what to do already, y'all.
All my niggas from the Hooters. All my niggas turn shooters. All my ops turn racks. All my niggas turn shooters. On the internet, you ain't been a threat. You been stuck in a computer. Show me.
You already know the vibe. All right, cool. So let's get back to this thing. Salute to y'all. Y'all dropping likes. I appreciate y'all. Boom. So let's go to this now. Bang, right? I can put myself here, but let me put myself. I'll put myself here. It's all good. So they see me there, right? Boom. All right. Okay, so where we at here, right? Over the time, did I go here? Circumstances, some of which were beyond the control of any of the parties or their respective attorneys. More specifically, during the course of this already complex case, prosecutors learned that the DEA agents from Atlanta who provided information material to the investigation were under investigation for professional misconduct. You know, that's Keith Cromer. You know, he was doing shit, but also we understand that Cuffy said in the case, I think it was like 5 agents were like fired and 1 agent was actually indicted. Okay, so we understand that happened. That Cuffy said that happened in this case. 5 agents were fired. I think at least 5 were fired and 1 was indicted. Okay, cool. Let's get back to the work. Cool. Prior to professional misconduct, right? The prosecutors promptly notified the court and defense counsel about the investigation. The investigation was by the OPR and the OIG. That's who opened up the investigation into Tammy Cowens and Keith Cromer, Special Agent Keith Cromer, and their illicit sexual affair that they were having while this case was going on. Okay, cool. I'm just updating y'all in real time, right? So investigation, the internal DEA investigation eventually evolved into a criminal investigation that became a centerpiece of a challenge by all defendants in this case to the constitutionality of judicial authorized wiretap evidence the prosecution intends to use at trial. In addition to this unanticipated development, this case, let me close this window, y'all, because I'm in New York, man. Police and ambulances every day, bro. Every day, bro. Just now, some guy just kicked a lady, an old woman. A Spanish man is on the news, just kicked an old woman, bro, down the escalator on the train, bro. Yo, New York is wild, bro. You don't know it, you better figure it out. It's wild. Listen. Cool. Where am I at? Where am I? Let me see. Long-term drug trafficking conspiracy. Wait a minute, I ain't get there yet. intended to use their trial. In addition to the unanticipated development, this case evolved from a long-term drug trafficking conspiracy into one involving charges for continuing criminal enterprise for alleged conduct dating back to the 1980s. You see what I'm saying? So this trial, it goes to show you how this did. You know what I mean? So Tammy coming out and doing all this from the gate is what led to this extra, you know what I mean? All this extra stuff. The Cuffy says that their case was falling apart. And when their case was falling apart, this is when they really try to sting him with all the other stuff, really, basically. And he just took a plea because one of his defendants, he didn't name which one. He said one of his defendants made statements that kind of binded him up. You know what I'm saying? Did they snitch on him like that? Possibility. But they probably said something like, yeah, he had a gun or we had a gun. Because we understand that he had to plead guilty to 2 ghost guns, 2 weapons possessions, which were federal type weapons possessions charges in furtherance of drug trafficking crimes. So the 2 weapons possessions was 17 years and 10 years for the conspiracy with the drugs and all that, which I don't understand how that still even went through good. When Tammy changed on her affidavit, her first initial affidavit, she switched on it, wrote 2 more, didn't submit them, didn't sign them. Slept with Agent Cromer and was getting monies and doing all type of lies and mischievous things. So I think that Cuffy and all 4 defendants had a case there within their Frank's hearing about Tammy and her proclivities, for lack of a better word. Okay, cool. So they said dating back to the 1980s, but I'm gonna bring back that sentence before we go. Say this case involved from a long-term drug trafficking conspiracy into one involving charges for continuing criminal enterprise for alleged conduct dating back to the 1980s. And death penalty eligible charges for 2 of Rush's co-defendants. It appears from the record that the government may have merged a separate parallel investigation related to 2 of Rush's co-defendants, Gatling and Andre Rush, into this case. See what I'm saying? So when Cuffy's saying they flipped the script on them and kind of, you know what I mean? That wasn't their initial thing. They just had the drug conspiracy. So it seems like maybe he may be leaning that right way to say, when the case started to fall apart, they was like, yo, nah, hit him with that. Hit him with that. You know what I mean? Hit him with that. So, you know what I mean? Y'all take it all with a grain of salt, but that's what Cuffy said. Cuffy's living paperwork. Meech is living paperwork. Tammy's living paperwork. Jack Harvey's living paperwork. Keith Cromer's living paperwork. I mean, joke on Tammy and Keith Cromer sometimes because of their love affair, but I don't take any of them as a joke. I really don't. I think they're fucking all serious people. Anybody that's on this paperwork is serious motherfuckers. I swear to God, I think that. So straight, nigga. I'm from the streets and I understand that. You feel me? So yeah, let's get back to this. Boom. So it appears from the record that the government may have merged. Okay, cool. There is no dispute that unusual circumstances that develop. Let me make sure I got y'all zoomed out the right way, right? No, I don't. See, I can't even see, man. Y'all even tell me nothing. Hold up, y'all. I was about to clap y'all. I want y'all to read with me. Hold up, right? Boom. So there is no dispute. Let me do it like that. So y'all see. There is no dispute that unusual circumstances that developed during the case dramatically increased the complexity of an already complex case and served as a recipe for delay beyond what would normally occur in a long-term drug conspiracy case. However, setting aside the unusual and complicating circumstances that were beyond any party's control, as described in greater detail below, there were delays in this case that were the consequence of strategic decisions made by defendants, strategic decisions made by the government, and delays related to the justice system. While the government should not be charged with delays due to circumstances beyond the control of any party or resulting from decisions made by defendants in the context of this due process analysis, the government must be held accountable for delays resulting from strategic choices it made and delays caused by the justice system. Canvassing the case law and concluding that unnecessary delays caused by the courts and the justice system are chargeable against the government in due process analysis. Delay beyond limits set by the Speedy Trial Act. The case was initially brought by one set of prosecutors, Assistant United States Attorney Matthew Drake and Jeanette Gravis, Jeanette Gravis, but was eventually taken over by another set of prosecutors, Assistant United States Attorney Dean Hoag and Michael Riley. At the arraignment on the first indictment on March 31st, 2014, Assistant Attorney Drake, U.S. Attorney Drake, announced that the United States would need time to turn over discovery and requested that the case be designated as complex because, among other reasons, it involved a long-term drug conspiracy case and the discovery was voluminous and was electronically stored and would encompass unindicted crimes, including murder of the alleged co-conspirator. Timothy Rush did not object to the complex case designation on April 9, 2014. The case was so designated. Based on discussions between the court and counsel at the status hearing on April 28, 2014, regarding the volume of the discovery and the format of the discovery, defendants were granted approximately 6 months through October 31st, 2014 to review the voluminous discovery and file pretrial motions related to electronic surveillance evidence. We know we went through all of that, like in the Franks hearing, and you all can see the Franks hearing. And the Franks hearing is where? It's online for free. DIONNEGATLING, Franks hearing. Okay. Sometimes it's going to be hard to find it. When you find it for real, it's going to be 32 pages. If you go through your phone and find it, it's going to probably be the third one from the top. And you're going to see a picture that's next to the words. You're going to see a picture of a paper that has red letters on the top of the page, like how these pages look, right? And the actual person that uploaded this Franks hearing, because some people can't find it, the actual page that uploaded the Franks hearing to Google is called Blocks Digital, BLOX Digital, or Blocks, BLOX Images. So put everything I just said in Blocks Digital or Blocks Images, and you should find the Dion Gatling Frank's hearing. And when you know, you'll find it, because when you find it, you'll see 4 defendants on the top of the page. You're going to see 4 defendants. You're going to see Dion Gatling, you're going to see Timothy Rush, his brother Andre Rush, and you're going to see Lorenzo Gibbs. Okay, that's the 4 people you're going to see on the top of the page. Scroll down, you're going to see memorandum. You know you're on the right page. You're cooking with grease. Now you're working. Okay, cool. Let's get back to this work. Cool. Y'all drop likes in the building. I appreciate y'all all. Y'all all make sure y'all dropping likes. Doesn't matter if it's 3 of us, 4 of us. Once we just drop our little likes, that's all that matters to me. We reading. We trying to break this thing down in real time and just get some understanding. That's all we trying to do. Feel me? Cool. All right. Evidentiary hearing set the week of December 8th. Okay, cool. All right. The 7-month period that elapsed between the arraignment and defendant's deadline for filing pretrial motions is purely a product of the complexity of the case, and as it was understood at the time and cannot fairly be chargeable against either party, delays resulting solely from inherent complexities in large multi-defendant cases were not chargeable against the government. Delays resulting from pending charging decisions and lack of access to e-discovery. Okay. Shortly before October 31st, 2014, pretrial motion deadlines for electronic surveillance evidence and under-designed learned at the status hearing that defendants would need an additional 90 days before they would be in a position to file pretrial motions. 3 seemingly independent reasons were cited as the reason for the delay. Specifically, Assistant U.S. Attorney Drake announced that the United States intended to file a superseding indictment that would add allegations, including allegations of homicide that may see what they did when they did this. So they did this in 2014. See what I mean? Because they was already ran down on them by like 2012 is when this thing went down. You know, August 5th, 2012 is the date in questions in the Franks hearing when Suarez and Gatling was supposed to be linking up. Tammy was debriefed. Okay. Tammy was debriefed on August 6th. Okay. She was debriefed on August 6th, 2012. Then she got this love affair. Remember when she was with Chroma and all this stuff with Chroma. She was with Chroma for 8 to 12 months. She said, "I don't know how she don't know how much months. How you get 8 to 12? It's either 8 or 12. That's me. Flat bid, sister. 8 or 12. What the hell you doing? Okay. Hey, don't let me call it. Might spoil it. Boom. Right? Superseding indictment of investigation, homicide, for hold up, that may potentially allow enhanced sentences for at least 2 of the 4 named defendants. Assistant Attorney U.S. Attorney Drake indicated that because the new allegations may render those defendants eligible for the death penalty before superseding, the United States Attorney's Office was seeking prior authorization from the Department of Justice on an expedited basis to not seek the death penalty. Assistant U.S. Attorney Drake felt that the prior authorization was necessary before the United States could file a superseding indictment, but was unsure when he would receive an answer from the Department of Justice. Drake expressed his belief that because the United States had already included evidence related to the as yet unindicted charges in its disclosures, any impact on pretrial motions would be minimal. The second reason given at the status hearing for extending the pretrial motion deadlines was that the existence of a separate ongoing investigation that could result in a new indictment, asserting very serious charges, including potentially death eligible charges for at least 2 of the defendants in the case. All counsels agreed that although the investigation involved a different set of facts, the indictment in a parallel case could impact decisions defendants in this case may make about pretrial matters. Assistant U.S. Attorney Drake was not involved in the parallel investigation, but said he would advise the court and defense counsel of the anticipated time frame for the conclusion of that investigation and any new indictment. Finally, during the status hearing, the court and all counsel discussed various barriers the detained defendants and their respective counsels were having in reviewing the extremely voluminous electronically stored information. Some of the issues related to the manner in which the discovery was assembled by the United States. Other issues related to the delays in the United States making available affidavits filed in support of applications for electronic surveillance, including wiretap and other electronic evidence, and other issues related to logistical problems at the local jails housing defendants, including their refusal to allow defendants to access court supply computers for more than 1 hour a day, or refusal to allow defendants to access attorney supply computers to review the electronic discovery. In light of the foregoing issues discussed at the hearing, defendants requested were granted a continuance of 90 days to January 30th, 2015, to file pretrial motions related to the electronic surveillance evidence. Most, if not all, of the 90 days extensions of the pretrial motion deadline is attributable to government. First, while I understand and commend the government's decision to wait for prior authorization to not seek the death penalty before filing a superseding indictment that may include death eligible charges, such a delay was not required. This is evidenced by the fact that prosecutors in this case ended up superseding 2 months before receiving official notification that they would not be required to seek the death penalty. Second, the decision to take and wait and see approach regarding the separate investigation that could result in a new indictment, against some of the defendants in the case was a choice made exclusively by the government, and at least one court has recognized such choices have consequences, particularly when defendants are in custody while awaiting trial. Finally, although the e-discovery accessibility issue was primarily an issue at the jails because the jails housing defendants are inherently part of the judicial system and because there is no evidence that the defendants caused the delays on that score, delays related to the difficulties in custody defendants had accessing e-discovery is attributable to the government, canvassing case law and concluding that unnecessary delays caused by the courts and the justice system are chargeable against the government in due process analysis. Delays caused by defendants' request to continue pretrial motion deadlines and hearing for the first indictment. As far as this is going to say, as the January 30th pretrial motion deadline approached, detained defendants argue they continue to have trouble accessing electronically stored discovery. The court and counsel discussed at the length possible solutions to the issues, including the use of an interview room in the courthouse for the purpose of permitting detained defendants to review electronically stored discovery, notwithstanding the issues defendants claim they were experienced. Defense counsel requested only 7 days in continuance of the January 30th, 2015. For example, defendant Gatling filed a motion outlining the issues he was facing in his jail. Although all of the issues were not uniform, defendant Gatling's motion is illustrative and of the issues generally discussed in the record. Oh, he's in jail. This is talking about he's in jail. Okay. Deadline that requested was granted, and the deadline for filing pretrial motion was extended to February 6, 2015, with evidentiary hearings to be set during the week of March 2nd, 2015. On February 6, 2015, defendants, including Timothy Rush, filed pretrial motions that, under design, directed the United States to respond by February 20th, 2015, and scheduled consolidated evidentiary hearing. Listen, I haven't slept all day, y'all. So if I'm reading this shit good, just understand I haven't even slept. I don't know how I'm seeing the paper. This shit look blurry. Look, it's crazy. Y'all drop a like. Boom. Extension for deadline for responding to pretrial motion. The United States filed its responses on March 4th, 2015. However, the consolidated evidentiary hearing scheduled on March 12, 2015 was continued to April 2027. No, it was April 27, 2015. I'm going all the way up in 2027 or some shit. The hell I'm going, right? Facts, right? I'll put me right there in the corner. All right, cool. Where's that? March. Pretrial hearing. Requested retained counsel for defendant Gatling, who cited multiple scheduling conflicts. Most, if not all, of the foregoing delay of approximately 45 to 55 days are attributable to the defendants and specifically to defendant Gatling. It was like, it's basically just threw it on him. Like, bro, he was taking mad long. He doing this, he doing that. They blamed it on Gatling. Delays caused by disclosures of DEA internal investigations and change of counsel. Several new developments arose that derailed the evidentiary hearing scheduled for April 27, 2015. By way of the background, the investigation into the defendants' alleged drug trafficking activities was initiated after the DEA case agents in St. Louis received information from a confidential source from Atlanta identified as CS1 Tammy. Information provided by Tammy was used to support the government's application for judicial authorization for interception of wire communication for a target telephone associated with defendant Gatling. When former retained counsel for Gatling filed his motion to suppress wiretap evidence on February 6, 2015, the motion and the attachments were not filed under sealed, and one of the attachments disclosed. Timothy Rush filed the motion to suppress, to disclose the identity of Tammy, CS1. Beginning in March Early of March 2015, Tammy expressed concern to DEA agents in Atlanta, both about her own personal safety and about the reputation and safety of a friend who was referred to in the Title III warrant affidavit. On March 18th, former retained counsel for Gatling advised the government via email that Tammy had contacted one of his associates and reported the wiretap affidavit factually inaccurate. Tammy also reportedly told the associate that the DEA agent in Atlanta who was referenced in the affidavit had been suspended or was under investigation. Attorneys for the government apparently looked into the allegations and shortly before the hearing scheduled April 27th, advised the courts then the DEA of a personal responsibility, the OPR. It was in the fact investigating one or more agents who provided material information to the investigation in this case for the for the possible professional misconduct. Salute everybody that's in the building. Make sure y'all dropping likes in the building. Everybody that has not dropped a like, make sure y'all drop a like. I'm reading this shit. Look at my eyes, y'all. Tired of shit. I haven't slept all day. When I say this shit, anything you see me messing up with the words, it's because these shit is blurry, son. Straight. The words is blurry. Straight, bro. Y'all make sure y'all getting the likes up. Come on, y'all. Y'all my peoples. I need y'all to get the likes up. When I'm on these type of videos, if y'all not getting likes up on this shit, I'm not reading it. I will make an upload video and I don't tell y'all nothing. I will say like in the beginning, like at the end, and just do my thing. But if we want to be real and live doing this, where we can understand, we can ask each other questions and we can talk to each other, we got to drop likes in the building. That's what motivates me. I'm telling y'all. Got to drop because that's what helps the videos to get out. Not us watching each other helps it. Y'all dropping likes, y'all commenting, y'all sharing. Share this video to your channels. Let's go. Right? In the midst of the revelations, retained counsel for defendant Gibbs was hired as an assistant United States attorney and had to withdraw from representation of Gibbs on April 10th. So when they came on April 10th, based on the representation that Gibbs could not afford to retain new counsel, the new court-appointed CGA panel attorney Steve Welby represented Gibbs. Welby promptly filed a motion requesting that the hearing scheduled on April 27, 2015 be continued for a period of 30 days so that he could prepare. I granted Welby's request and converted the evidentiary hearing scheduled on April 27, 2015 into a status and scheduling conference. So I know that we right here on this page right here. Yeah, we right here. This is where we at right here. Yeah, man. Salute to everybody. If you dropped a like, salute to you. Salute to everybody that has dropped a like. You already know the vibe. I need everybody to make sure they violating that like button, busting a shot on that like button. Do your thing, bro. We need to get the likes up because that's what get these messages out. Especially, I'm tired as hell. I'm reading for y'all. Some of your favorite YouTubers can't read. I'm not putting them down. I'm just saying, let's be real. You ain't over there liking some shit on their channel because they could read. It's okay, cool. I would like that. I would like you to do that for me. Thank you. Everybody drop a like when you watch this. Everybody drop a like because I'm gauging how y'all doing. If not, I'm going to start doing uploads. And y'all could just talk to the recorded version of me. Straight. Honestly, I love you all, but I have to get to this work.
All my niggas from the Uda. All my niggas turn shooters. All my ops turn racks. All my niggas turn shooters. On the internet, you ain't been a threat. You been stuck in a computer. Show me.
At the April 27th status hearing, Assistant U.S. Attorney Gravis disclosed the OPR Internal Affairs investigation to all counsels because it was unclear the targets of the investigation were aware of the investigation. Assistant U.S. Attorney Gravis made the disclosures at a sidebar and requested that Mr. Welby subsequently appointed as the federal public defender in the Southern District of Illinois. The record to be sealed. During the course of the discussion at sidebar, Assistant U.S. Attorney Gravis acknowledged that based on what she knew of the investigation, all defendants were entitled to a Frank's hearing. Gravis further acknowledged that the defense counsel were entitled to an additional disclosures relative to the investigation pursuant to their government's obligations under Brady, Bagley, and Giglio. Assistant U.S. Attorney Gravis indicated that she would disclose the information subject to a protective order, which would be filed immediately because defendants had already filed pretrial motions at the time of the hearing. I reopened the pretrial motion deadline to allow defendants time to supplement their previously filed motions and filed any other substantive pretrial motions that were unrelated to electronic surveillance evidence. Okay, based on this discussion held both on the phone and in open court at a sidebar as newly appointed counsel for Gibbs, Welby made an oral motion to continue the evidentiary hearing for at least 90 days. There were no objections to the request, and it was granted. Following the hearing, the government was required to make disclosures about the OPR investigation and to the defendants by May 7, 2015, and defendants were required to file supplemental motions under seal or before June 22nd, 2015. The evidentiary hearing was scheduled to be on August 4th and 5th, 2015. So they want you to get your number in quick. Cool. This is the page we're on now. Salute to y'all if y'all dropped a like. Salute to everybody in the building that's dropped a like. Salute. If you haven't dropped a like, you know what to do.
All my niggas from the Uda. All my niggas turn shooters. All my ops turn racks. All my niggas turn shooters. On the internet, you ain't been a threat. You been stuck in a computer. Show me.
Facts of life. Salute to everybody that's dropping likes, man. This is the Go sector. This is the Go network. This is the Go gang, man. We all on Go for each other. This is what it is. We drop likes. We show love. This is what we do, son. I'm from the streets too, son. I'll run down on the app. We can run down on the app on the YouTube streets of real world. That's okay. But we got to be able to show love, because that's what people don't do, and that's what people can't do, bro. They can't show love, bro. And when people show love, it's always for selfish gain. Take care of yourself. I get it. Some narcissism is okay when you like to make sure you look good. But yeah, it's a lot. You know what I mean? It's a lot. So salute to everybody. Salute to everybody that's here rocking with the Cook Up Show, man. We cooking up in real time, man. You see me cooking up all day, midnight. I haven't slept. I did lives this morning, lives last night. This is what it's all about, man. Salute to everybody, man. I'm going to be back with another part to this. We got a few more pages of this. So I'm going to cap this here. Make sure y'all all subscribe to the channel, hit notified, because I'm going to do it today and probably I might do the next part right now. I might tell it right now. So I'm going to be doing this next part, cap it out. Boop. So we all could watch it back. We watch it. We get the information. We could process it. It's not too much for a younger viewer, because younger people also watch me as well. So that's why I'm also trying to clean up some of the things that I do sometimes. You know what I mean? When I be joking and we're going reckless with the, you know what I mean, with the cursing, because, you know what I mean, young people watch it. So salute to y'all, man. You already know the vibes. You already know we be on. Uda, Uda, Uda. We always on Go. Stay on Go.
All my ops turn racks. All my niggas from the Uda. All my niggas turn shooters. All my ops turn racks. All my niggas turn shooters. On the internet, you ain't been a threat. You been stuck in a computer. Show me the proof. All my niggas turn shooters. All my niggas from the Uda. Welcome to the Uda. All my niggas from the Uda. All my niggas turn shooters. All my ops turn racks. All my niggas turn shooters. On the internet, you ain't been a threat. You been stuck in a computer. Show me the proof. All my niggas turn shooters. All my niggas from the Uda. Welcome to the Uda. All of my niggas insane. they tryna catch a mistake. Young niggas putting in pain, it in the game, all for the game. Niggas ain't playing for nothing, went in school, laying in bang. My little nigga kill my little nigga, full-time job not to kill niggas. Jump off the porch of the field, nigga. You was in the house, I'm a field nigga. No fuck boys around real niggas, been a drug dealer since a little nigga.